Thanks very much for joining us this afternoon. I'm Paul Paton. I'm Professor of Law here and Director of the Ethics Across the Professions Initiative, which is a 10-year grant funded by the Sierra Health Foundation to encourage and promote dialogue about ethics in different professional contexts. We're very privileged to have their ongoing support renewed for 5 years this past year. They've supported talks and symposia on ethics in government, judicial ethics, the changing face of the legal profession in light of globalization and technology, as well as a number of other individual speakers. And we're really privileged this afternoon to have David Vladeck joining us on campus this week for a number of different talks, including a faculty talk this afternoon, today, some classroom discussions and other dialogues in addition to this session. So for purposes of this presentation, we invited David to speak under the title Completely Clueless or Completely Venal, which in terms of building on his experience in particular with the Federal Trade Commission and as director of the Federal Trade Commission's Bureau of Consumer Protection, struck us as a particularly appropriate way to work in the ethical part of the conversation, encountering government, and in particular corporations encountering government. It's not necessarily the case that you're going to see discussions about ethics in that context, but we thought that might be a very good way to introduce that part of the dialogue into the discussion this afternoon. Professor Vladeck teaches federal courts, civil procedure, administrative law, and co-directs the Institute for Public Representation, which is a clinical program specializing in civil rights and civil liberties litigation at Georgetown. Before joining the Georgetown faculty in 2002, he had spent over 25 years with Public Citizen Litigation Group, which was handling and supervising complex litigation. Our colleague John Sims as well, of course, a colleague of David's and a good friend. David's argued a number of cases before the United States Supreme Court, more than 60 cases before federal courts of appeal and state courts of last resort, testifies frequently before Congress, writes on administrative law, preemption, First Amendment, and access to justice issues. While he was at the FTC, he supervised more than 450 lawyers, investigators, paralegals, and support staff who carry out the Bureau's work to protect consumers for unfair, deceptive, or fraudulent acts or practices. And just in advance of this discussion this afternoon, we discovered a few links to Canada that will come up in the context of the conversation this afternoon. Who knew about those Canadians? It wasn't just Celine Dion and Monty Hall that were going to disturb Americans. So we'll actually look forward to that part of David's talk this afternoon. At the FTC, he led the agency's efforts to shut down last dollar frauds, to fight abusive debt collection and mortgage foreclosure practices, something particularly pertinent to the Sacramento area and indeed to California, to stop national advertisers from making unsubstantiated health claims, and privacy protection as well, both through law enforcement and policy making. He received the agency's Distinguished Service Award in December 2012 and was recently named by Newsweek, The Daily Beast, as one of the most important quote-unquote navigators of the digital economy, ranked highly in the publication's Top 100 Digital Power Index, so I look forward to hearing more about that. In 2010, he was profiled as one of 10 game changers and one of 50 politicos to watch by Politico. Those of you who are political junkies will know all about Politico. And in 2008, he was named one of 30 champions of justice and one of 90 greatest lawyers in Washington, D.C. over the past 30 years in the 30th anniversary issue of the Legal Times of Washington. So bringing to us and to this discussion this afternoon a distinguished career in the academy and in government, and in particular at the FTC. Looking forward very much, David, to your discussion of Completely Clueless or Completely Venal, and looking at corporate encounters with the FTC. Thank you very much for joining us.
So let me start with a disclaimer. I am still a consultant to the Federal Trade Commission, but nothing that I say today should be attributed to the Commission. I want to explore a question that has vexed me for the last 4 years. The Federal Trade Commission, at least my bureau, is fundamentally an enforcement agency. As Paul noted, there are 450 people who work in the Bureau. Most of them are lawyers. And at any given time, we have between 100 and 125 enforcement cases pending. We have maybe 300 investigations ongoing at any given time. And one of the classic arguments we hear is, I just didn't know. I didn't know. And of course, one of the classic arguments we never hear, but we can conclude on our own, is these people are completely venal. And so one of the questions that I've pondered, and I've actually discussed this with some of my other law enforcement colleagues, is which is worse, which is harder, which presents the more difficult situation as a law enforcement person? Which would you prefer to be dealing with? So let me start out by asking you guys, how many people here would prefer to deal with a potential defendant who is plainly, completely clueless? How many would prefer to deal with someone who's completely venal? Nobody. So one tepid, somewhat uncertain stab towards the venal. And I think it's always a good rule to gravitate towards the venal. But most of my enforcement colleagues say venal. And I want to talk to you today and give you some paradigmatic examples of defendants in enforcement cases, actual enforcement cases, that sort of show the two poles, the truly venal and the truly clueless, and ask you to reconsider your judgment at the end of this. So I want to talk about starting out with the venal, because in some ways it's easier to describe conduct that's truly venal. And here we get to make fun of Canadians right off the bat. So in 2007, the Federal Trade Commission launched an investigation into the conduct of MoneyGram. MoneyGram is the second largest wire transfer company in the world, edged out only by Western Union. We started investigating MoneyGram because of wire transfers to Canada and the extraordinary high volume of fraud that was being reported to the Federal Trade Commission. Now, the Federal Trade Commission, among other things, maintains the largest fraud database in the world, and it's used by law enforcement agencies in the United States to detect fraud and to target enforcement targets for fraud. And we get about 2 million original fraud complaints a year. Many come directly to the Federal Trade Commission. Many are funneled to us by better business bureaus. But we were starting to see a real spike in fraudulent cross-border activity from Canada. And, it reached the point in 2007 where 70 or 80% of the cross-border fraud was being committed using wire fraud as the instrumentality. So for those of you who are not familiar with wire fraud and why bad guys like wire transfers so much, it is the least traceable form of moving money around. It is the bane to law enforcers. More money laundering and more money trafficking is done through wire transfers than any other form. It's just so easy. You wire money somewhere, someone picks it up, they disappear, and you can't trace the cash. There are no fingerprints. There are no serial numbers. There's no real recordation. So there were 5 or 6 standard scams run out, mostly out of boiler rooms in Montreal, that we knew were scamming American consumers out of tens of millions of dollars. So you're probably familiar with a lot of these scams. Lottery scams, prize scams. People get a notice in the mail or they get a phone call, congratulations, you won the lottery. Well, that may be odd because I never entered it, but don't worry about it. There's $10,000 check waiting for you. We just need you to pay the taxes and the custom fees. So wire us $300 and this $10,000 check will be yours. So lottery and prize scams, huge. There are boiler rooms in Montreal who do this day in and day and night. Advance fee loan scams. So people are searching for loans on the internet, and someone will call or send them an email, or they'll be marketed through telemarketers and say, yeah, we're going to loan you that $5,000 you need. You just need to send us $250 to pay for the fees to set up the account. Very common scams. Mystery shopper scams. Huge Everyone wants to be paid to go shop at Walmart. These scams are rampant. Fake check scams. These are very sophisticated scams, and increasingly the targets are law firms. People get a fake check, very often very large check, and say, this is a retainer, we need you to do something for us, and please just send us back a little money. Of course, the banks have a very difficult time separating the wheat from the chaff. So the banks often clear, at least temporarily, the check. For the consumer who says, is this a good check? The bank will often say, yeah, it's a good check. And then, of course, 30 days later, when it turns out, there really is no bank of, whatever it is, the consumer's left on the hook. And then, of course, there's the grandparent scams. These are the scams Facebook and other social media have enabled. People now know the names of relatives and kids and so forth. And so people get calls in the middle of the night. Their son's been in an accident. Their son's been arrested. All you need to do is wire a few $100s here and everything will be made right. And wire transfers, of course, are easily facilitated. Every Walmart in the country has a MoneyGram outlet. Half the liquor stores in Detroit have MoneyGram outlets. It's not hard to find one. So I want to just read from you some of the reasons why we thought it should have been crystal clear to MoneyGram that their operations were rife with fraud. And I'm just going to give you a tiny slice of some of the evidence that we assembled. So starting in 2006, that's when we really started looking from 2006 onward. So there were about 1,450 agents in Canada that received at least one wire transfer from the United States of any size. Of those, 1,300 out of the 1,450 had no fraud complaints at all. Their average transaction was $440. What about the remaining 150, you might ask? Well, these accounted for over 99% of the fraud complaints, and they collectively, just in 2006, received $83 million, more in excess of $83 million from U.S. consumers. The average money transfer received by these agents was over $1,700. Okay, is that a clue? 2 years later, and I'm just giving you a taste of this. 2 years later, MoneyGram had about 1,240 agents in Canada that were receiving large volumes of checks from the United States, large transactions. About 1,100 of them had no fraud complaints. Unfortunately, the other ones, the remaining 135, had huge numbers of complaints about transfers in excess of $1,000. These agents were responsible for 96.7% of the complaints, and collectively they received over $94 million in wire transfers from Americans. Now, what was going on in these outlets? Well, in one outlet, in Ontario, in fact, we found one office, the largest one in Ontario, had written the names of the recipients down along with their driver's license. And they had 2,655 Ontario driver's license, of which only 45 were actually verifiable, true license plate numbers. Most of the other ones had extra digits. So anyone who's familiar with an Ontario license plate would have known from the outset that these were fraudulent. I could go on, but this was just one little piece of the evidence that we were able to amass against MoneyGram. So we sued MoneyGram, and we had a dilemma, and we were talking about this earlier. We could have insisted that MoneyGram pay back all of the money we believed was scammed from U.S. citizens. Of course, we couldn't trace most of them. We could trace, and because of complaints filed with us and with MoneyGram, we could trace about $18 million. But our remedies, and I'm glad that McGeorge still teaches students remedies because most of our lawyers struggle with these issues. We do have the authority to seek disgorgement of ill-gotten gains. And so one of the things that we could have done was insist that MoneyGram cough up all of these huge amounts of money that ended up in Canada as a result of fraud. And we decided not to. And this is the problem dealing with completely venal companies. By the time we sued MoneyGram, everyone, literally everyone in a management position had been fired. Most of the Canadian agents had been indicted by, and many of them convicted, by our very able counterparts in Canada. We work very closely with the RCMP and with the Competition Bureau up there, which has a similar function. So we wouldn't have been able to bring the MoneyGram case, but for the cooperation we received from our Canadian counterparts. But one of the difficult questions, and this raises the ethical dilemmas that enforcers have, is do you put a company that has now sort of undergone a complete transformation as a result of this investigation, and subsequently, and we knew this was going to happen, MoneyGram entered into a deferred prosecution agreement with the Department of Justice in November, requiring them to pay $100 million, which will be used to compensate other victims of these frauds. So, but the question is, should we have put it out of business? And ultimately, we decided not to, in part because we didn't want to leave Western Union as a monopolist, and Western Union has its own problems with fraud. So that's the first completely venal. And MoneyGram's defense was, yes, we are completely venal. That's why we fired everybody, and we have no defense on the merits. Who would have thought these perky Canadians would be thieves? That was not their defense. It didn't take us very long to figure it out. And so we entered into a very, very, very strict, highly prescriptive order with MoneyGram that requires them to do all sorts of things, ranging from the amount of transfers to verification procedures to anti-fraud measures, and we get all of their data. And the level of fraud in their money transfers has plummeted as a result, and they're still in business. But that is a defendant that was completely venal, admittedly completely venal. Let me talk about a garden variety scam where I think there was no dispute that the people who ran it were completely venal. So there are a lot of people out there who have poor credit, can't get payday loans, they can't get credit cards, they have no access to credit. And scam artists prey on these people. And these are, if there's one group of people that the FTC really sort of tried to protect, it's people who are rendered vulnerable in this way. But companies, scam artists get sucker lists. So there are tons of come-ons on the internet, on TV, urging people to apply for and get easy credit. And the come-on is, we know you've got bad credit, but we'll give you a credit card, we'll help you repair your credit, we'll help you get back on your feet. And so people enter their personal information, sometimes their bank account information, sometimes other information, on the internet, on forums, and then they're solicited by bad guys. We call these sucker lists. One particularly egregious scam was conducted by companies called the Platinum Trust Card and the Express Platinum Card. Notice platinum seems to be the selling point here. So they were very aggressively marketing, telemarketing. They redlined neighborhoods, and they were looking for poor people with bad credit. And so here was the come on. We promise you a credit card, general purpose credit card, just like Amex, just like MasterCard, with a $5,500 credit limit. And as soon as you start using this in a responsible way, we'll report this to the credit agencies, so we'll help repair your credit. And this is going to be cheap. There'll be a $69.99 original startup fee and only $19 a month thereafter. And we had a lot of the scripts and we had a lot of the calls. And there were often questions from consumers. So, can I use this at Walmart? Can I use this the way I use any other credit card? And the response was always, of course, this credit card is just the same as MasterCard and Visa or Amex. Wherever these cards are are accepted, so too will your card. Well, all of these things, of course, were just huge lies. For one thing, they debited consumers' bank accounts for far more than was authorized, often up to their credit limit. They never got a credit card. They got a thin piece of plastic that said Platinum credit card, but it was not recognized by anyone. The only thing that this card entitled them to do was to shop at Platinum's websites, which were plainly designed to discourage people from shopping there. They were stacked with random, off-brand, overpriced, downright bizarre products. My favorite was, in generally in comically large sizes. My favorite was a bulk package, 72 unit package of washable poster paint for $863.28. Now, I know if you have a burning desire to get this product, you might check Amazon, which sells exactly the same thing for $103. And here's the irony. They couldn't even use their Platinum Trust Card to buy from this bizarre website. All they could use that credit for was to pay for the shipping and handling. So we shut these guys down. We took all of their assets. We were able to do full redress in this case, and they will, if we're lucky, they'll end up getting indicted. But they had no defense. What they did was completely venal. They targeted the most vulnerable people, and they did everything they could to drain the last dollar out of their wallets. Okay, so those are the completely venal people. Let's talk about the completely clueless. And, I can't help it. I don't want to do this, but I got to talk about Google. Google is the largest data collection company in the world, and in some ways it is far and away the most sophisticated. But every time it gets into trouble, it says, we just didn't know. So the one that I find most fascinating is Google's defense to Google Wi-Fi. This is Street View. This was very controversial. As you know, Google equipped cars with these very elaborate cameras, and they go around photographing every street. I assume everyone in this room has used Google Street View once. What Google denied doing, at least initially, was gathering what we call payload data as they were doing this. So payload data is trying to figure out what is going on in unencrypted Wi-Fi hotspots. Now, why are Wi-Fi hotspots important? For everyone who has a cell phone, who uses a geolocation-enabled app, like Google Maps, Wi-Fi hotspots and knowing where they are hugely important. Because there may be cell towers, there may not be, but the most accurate geolocation, triangulation, comes through Wi-Fi hotspots. But Google wasn't simply mapping where these hotspots were. Google was also pulling down what we call payload data, which is the unencrypted traffic in that area. And Google denied doing this. It denied it not just to American regulators, but it denied it to the European regulators. And at some point, Google had to go, whoops. We were wrong about that. It turns out that our cars were all equipped with devices to capture massive amounts of unencrypted data about payload data, about if you're on an unencrypted computer, where you're going to meet your spouse for dinner. And Google's explanation for this was, we didn't know. Now, this was the largest collection of personal data by any entity other than government, presumably, ever in the history of the world. And their response was, we didn't know. This cost Google a fortune to do. Their response was, we didn't know. And what's really interesting about this, and I don't have to rely on anything the FTC did, because the FCC also conducted an investigation. Our investigatory records are not public. Theirs are. And the FCC wrote a 25-page report basically verifying Google's explanation for this. And Google's explanation for this is simple. We want our engineers to be creative. The guy who designed the system is a German engineer who was being creative. He figured if we can capture all this data, we may be able to analyze it and find something useful. So we're just going to capture it all and send it to Mountain View and send it to other repositories around the world, and at some point we'll analyze it. And what's interesting about this is he tried to communicate these plans to senior Google officials. And there are lots of emails this engineer is sending to people higher up, and one doesn't bother to read it. One says, consult with the privacy people. He doesn't say whether this is good or bad. He doesn't, of course, do that. But there is no interaction between this engineer and more senior Google people. So Google has, I think, made an entirely credible defense that they were entirely clueless. Now, why they thought that was a good defense, I don't know. But Google has had other problems, two of which have resulted in FTC consent orders. One with the rollout of their social networking site, Buzz. Google was trying to use their email dominance to create a social network site that would rival Facebook, and did a very poor job in trying to persuade people to allow some of their contact information to be disclosed. And Google claims this was a combination of inadvertence and clumsy engineering, but when Buzz was launched, a lot of people had contact information disclosed that they didn't really believe would be disclosed. Now, it may not be a big deal for many people, but for psychiatrists, for people with angry spouses and, former spouses, for people who didn't want their political affiliations to be disclosed, this was a very big deal. And, we ultimately sued Google and entered into a very complicated consent order with Google. But Google's defense essentially was, we're sort of clueless, followed on by our subsequent enforcement action against Google for Google Safari. Google had promised users of Safari that if they didn't want to receive Google tracking cookies, it's the way advertisers and others follow people around the internet, they had to do certain things. Well, turned out not to be exactly right, and Google was able to put tracking cookies on the, on the computers of a lot of Safari users who didn't want to be tracked. And again, their defense was, we didn't really know. So this presents a real dilemma for regulators. It's a growing company. It's incredibly innovative. You don't want to somehow inhibit the development of new technologies, of new services. On the other hand, if Google makes a promise, a commitment to consumers that it's going to hold the consumer's information private or going to shield it from public view, Google, as the steward of that data, has an obligation to do it. It's an obligation enforceable by the Federal Trade Commission. And so if you look at our order in Google, it is almost the antithesis of the order in MoneyGram. MoneyGram is highly prescriptive. It requires, we basically have laid out best practices for MoneyGram to follow, and if it doesn't do it, we'll clobber them. And that was our bargain with MoneyGram. With Google, it's much more general. I mean, there are really only four major provisions. There's one, don't lie. Okay, that doesn't seem like it. The second is, if you're going to change your settings in any way that would result in the disclosure of additional private information to third parties consumer hasn't consented to, you need to notify the consumer and get affirmative express consent. And then the other two key operative provisions were in some ways novel and in some ways a way of signaling to the rest of the community. We said, look, you need a cradle-to-grave privacy policy that addresses product development, Google Wi-Fi. No one sort of thought about privacy as you're developing this. And you need to have this soup to nuts, a complete privacy policy, and you need to get outside auditors every 2 years to come and do a top-to-bottom sort of review of whether you're actually doing what you say you're going to do. And the first of those audits has just come in. But if you look at the orders, they are completely different. Let me talk about one more completely clueless defendant. And then I sort of want to talk more generally about the dilemma this poses. So all of you know what mobile apps are, right? So there is an incredibly diffuse industry out there. Thousands and thousands of mobile app developers. There's a statute called the Children's Online Privacy Protection Statute that says, in essence, one may not track on the internet anyone 12 and under without their parental permission. So you can't gather any personally identifiable information about someone 12 and under on the internet without parental permission. Now, there's no question that smartphones and tracking devices are covered by the statute. And increasingly, we are seeing app developers, and most of these are 25-year-old kids in their basement, developing apps that do just that. They track geolocation information, they take down contact information. There's very robust sort of transmission of information. And by the way, your smartphone, just think of this as an information sharing device. I mean, there are so many players in the ecosystem that can pull information off this device. It's worrisome, but you're all grown-ups, you're making choices about what you're willing to share with third parties. But the Congress has said, with respect to kids, it's not up to the kids, it's up to the parents. And so we have been engaged in a lot of investigations with these folks. And with respect to many of them, their excuse is, gee, we didn't know there was a law out there. We ask them, why are they collecting this data? Because they're not really able to monetize this data yet. They say, because it's cool, we can. So these are plainly people in the completely clueless. These are not fraudsters. These are not those agents trying to fleece American consumers. These are just really highly skilled, technologically gifted kids trying to devise products that they think will they'll be able to sell on the market. So what do we do about these guys? There's a cost to getting a defendant under order. Every time we sue somebody and get them under order, we assume an obligation, generally for 20 years, to follow this person around. Among the ordinary provisions that we have in our orders are reporting provisions to the FTC. You've got to tell us where you are, you've got to tell us what you're doing. And often you've got to tell not only us what you're doing and where you are, but you have to give copies of this order to all of your future employers. You have to essentially notify everybody that you've been subject to an FTC enforcement action. Not a good career move for a young technologist. So do we want to ruin their lives? Do we want to get them under order? They're plainly violating the law. We have an easy case against them. What is the right answer with respect to those kinds of completely clueless people? And that's why I think this debate is so interesting. With respect to MoneyGram and Platinum Trust, we know what we're going to do. We're going to do whatever we can to either force a wholesale change in the business model, or we're going to shut them down. And we can write orders that are very, very difficult to comply with, and compliance is costly, and there's notice to third parties, and we have a very robust ability to get data and to really oversee what they're doing in the future. It's the path we took with MoneyGram, it's the path we took with Platinum Trust. But with respect to the clueless, it's more challenging. And so I've come out tentatively, I need to think about this more, that it's much more challenging in some ways. It's much harder for regulators to deal with the completely clueless. I do think that even though the FTC doesn't have the authority to punish, we have all of our remedial efforts have to be to deter misconduct in the future-looking remedies. We're not a criminal agency. We can't put anyone in jail. We can ask a court to impose civil penalties. We can't impose civil penalties on our own. But with respect to the venal, we can just use our full arsenal of equitable authority to really tie their hands and to make sure they're not going to threaten consumers again. But with respect to the completely clueless, it's much harder to do that. I mean, I was very disappointed to enter into a consent decree with Google and to see just a couple of, within a year, Google in violation of the order. That was not my expectation. Frankly, it wasn't Google's expectation, and there was nobody more chagrined than Google. Google didn't want to be there, and we settled with Google very quickly. But it is, you know, is it the growing pains of a new corporation? Is it okay to be completely clueless? You know, I talked to their general counsel at length, and I said, you know, this defense, why do you think this is a good defense? Coming in here and saying we really weren't in control of what we were doing. Why shouldn't that scare the bejesus out of me as a law enforcement person? And he didn't really have a very good answer to that. And so I'm not sure I'm going to come down hard and fast on the side of the completely clueless, but I do think that as a regulator, if I had my druthers, and of course you don't, I'd like to see more of the completely venal than the completely clueless. Let me just add one thing. Many of the cases that we have fall clearly within the completely venal side. Most of the work we've been doing for the last 4 years has been anti-fraud cases. If you look at just our docket and you look at maybe the 400 cases we've done in the last 3.5 or 4 years, the bulk of them have been anti-fraud cases like Platinum Trust or MoneyGram. But there are cases that sort of fall in the middle, and these two are difficult ones. So I want to just talk briefly about some of the national advertising cases that we did, and we talked a little about some of these over lunch. The agency had not been aggressively enforcing the anti-deception laws with respect to national advertisers. And when we came into office, a political appointee, when the chairman and I sat down and talked about what the Bureau ought to be doing, one decision we made was to take a hard look at national advertising, particularly with respect to what we thought was a proliferation of health and wellness claims. You can't go into a grocery store, you can't watch TV without some product telling you it's going to make you better. You're going to be healthier, you're going to feel better, you're going to be stronger, your butt's going to be more attractive, a lot of that. And we started taking a hard look and suing a lot of national advertisers. Kellogg's a couple of times, Nestle's, Dannon, Reebok, Skechers, Palm Wonderful, Nivea Cream, Oric vacuum cleaners. And, you know, these cases, in my view, sort of fall in the middle, and they're sort of hard. They're also hard to deal with. So the question is whether you can make these kinds of health claims, and if you can, what kind of substantiation do you need to back them up? And in many of these cases, the company had some theory as to why the health benefit would accrue. You know, in Dannon, this is the famous Dannon Activia commercial with Jamie Lee Curtis with this magic, you can't see this magic arrow appearing on her belly. Which was a clue that was to communicate an act that I don't think they wanted to talk about with any greater precision than maybe this. It is true that if you eat a huge amount of Activia yogurt, you may get this effect. But you need to eat a huge amount of it. And so ultimately we settled with Dannon in a way that reformed substantially their advertising. With respect to Nestle's and Kellogg's, they ended up reforming their advertising. With respect to Skechers and Reebok, we insisted on redress, and we'll send out, we've already sent out, I think about 320,000 checks of about $65 each to Reebok purchasers. We'll end up doing about the same, just probably 420,000 in Skechers. And, you know, you talk to the advertising industry about this, and, you know, part of their part of their response is, well, in some ways, we thought what we were doing was sufficient. You know, these had been the standards in the past. I'm skeptical of that. But these are companies with enormous reputational interests. You know, they don't want to be sued by us. You know, I'm the last guy they want to see. I'm sort of like the gym teacher at the, you know, at the final dance of the year. Nobody really wants to see the gym teacher, the proctor. But, you know, those cases bother me because I think that the companies knew that what they were doing was more than puffing. They were making claims that were more than exaggerated. They were making claims that at the end of the day, they really couldn't defend. And so at some point, I want to answer the question, at least in my own mind, is this an element of Clueless? Was this an element of venality? And what do we need in order to really move the law on that issue? But this is an issue that I think regulators spend a lot of time worrying about. And I think I come down on the side of the completely venal. Anyway, I've been talking for a long time. I'm happy to take whatever questions or comments people may have. And those of you who voted completely venal at the beginning, have you changed your minds? Yes?
Well, the reason I voted completely clueless, the punchline I thought was going to be, people have been venal since there have been people, and there will always be venal people. You try to police them on the edges, but it seems to me completely clueless may be a more recent phenomenon because of the incredible complexity of law. So I'm thinking of these app makers who really are completely clueless, and they're just pushing technology. They don't. Do you see a greater role in regulators rather than chasing after them after they've committed the offense, helping to dispel some of the cluelessness?
Well, I see that as our principal job. And in fact, you know, one of the reasons why we haven't just sort of, to use a bad phrase, carpet bombed this industry with enforcement actions is because we've been spending a lot of time. We've issued now in the last 14 months 3 comprehensive reports on mobile apps that are very clear about what our expectations are. We have a lawyer in our San Francisco office whose job it is to do outreach to this community, and that's what she does. She gives lots of talks all the time to the app developers. But the industry is really diffuse. And you know, when we work with their trade associations, we work with law firms. So we are trying to get the message out. The question is, how long can you do that and not see the kind of changes in the industry that we need to see? And, you know, by our lights anyway, we've been quite patient. And so at some point, when the channels of communications are not sufficiently developed to ensure that you're really reaching this audience, is enforcement a correct tool to use in order to amplify that message? And that will be for my successor to decide. But it's a tough question. Yes?
I would just follow up on Dave's point. It seems like with this particular industry, because of the nature of the techniques and this innovation, that it's not just beware of privacy, it's just the whole issue of social boundaries that are very different with different generations and experiences and consumer experiences as well. So it seems like it's not just the law or the regulation, but it's almost this behavior, worldview of personal boundaries.
You know, I agree with you, though. You know, our mandate here is more narrow than that. And, you know, we've pushed very hard. I mean, there are 2 real gatekeepers here. There's Apple and Android and Google. We've tried to push the gatekeepers as well to work on those normative questions. Because I agree with you, those normative questions are enormous. But, you know, there's also a failure of design. I mean, we've been talking a lot about privacy by design, and current generations of smartphones are getting better and better and better at enabling consumers to keep information private. But the first generation of smartphones were SIPs. And they were not really designed very well to ensure that whatever choice you made about geolocation data, for example, would be respected. You know, there were a lot of apps, like battery apps, that have nothing to do with geolocation, that at least in the first generation were pulling down your geolocation data. And they were doing it because they could, and because they were hoping to monetize this with advertising that was geographically based. And the technology has in part helped answer some of these questions, because if you look at the current generation of Apple or Android phones, I haven't taken a look really at the Microsoft or the RIM ones, but they're much better designed to enable you to ensure that your preferences are respected. But the normative question is important. Yes.
In this health and wellness segment, it's my understanding that the FTC is putting what appears to be a lot more energy toward the internet direct marketing model than toward national advertising. And I'm seeing the same weird ads on TV for green coffee and things like that it seems the FTC is going after internet marketers for. Is that because of the product itself, or is that because of internet marketing techniques like negative option?
Well, we're really unhappy with negative option ads, and we've spent a huge amount of time trying to clean up commerce on the internet. But all of the advertising I just talked about, these were national ad campaigns. I mean, I thought we sued them over them, but I thought the best advertising campaign I had seen in years was the Palm Wonderful campaign. It was great ads. They just made it clear that they thought, men were going to avoid prostate cancer and heart disease and ED and all sorts of other things. Pomegranates are great. It doesn't do that. Kellogg's, those ads were unbelievable. They were huge national advertising campaigns. The first this was my favorite. Kellogg's decided to promote Frosted Mini Wheats as the key to your child's success in school. And so the ads were that if you served your child a nutritious breakfast of Frosted Mini Wheats, he or she would be 22% more attentive in school. Huge national advertising campaign. Now, first of all, putting aside who knows what attentiveness means, the study that they produced reduced to its sort of silly essence, would have made the same claim if your child had eaten a Twinkie and swallowed a bottle of Coke, because the comparison was
26%.
That may have been 28%, but the difference was between a child who had eaten something and children who had eaten nothing. And of course, the study didn't really tell you what it meant by attentiveness, and even worse, it was nowhere near 22%. And the next Kellogg's campaign was a beautiful campaign. It was a great campaign. It was just a shame it wasn't true. They had this beautiful woman with this beautiful child, and this was right in advance of the H1 flu season. And the claim was, if your kid ate Rice Krispies, it would build their immunity and avoid colds and flu. Rice Krispies is a flu fighter? Not really true. So a lot of these cases, Dannon, Nestle's probiotic, huge campaign, Nivea Cream, huge campaign. For those of you out there who don't remember, this was another favorite. This was My Silhouette. This was a cream that you could, the ads were great. So there's a woman sort of looking in her closet and wistfully pulling out the pair of old jeans in the back that she wore in high school, but she can't quite get into. And the come on was, you slather some of this cream on you, you'll be able to get into those old jeans. Now, this isn't lard we're talking about. This is some other form of cream that was supposed to compress your midsection. Please. But these were big national ads. Now, in addition to that, we've been going after a lot of internet marketers for things like negative options when you find yourself signed up for something that you never agreed to, the gym membership, the travel club, whatever it is. Congress has stepped in a little with Roscoe in terms of pre-acquired account information. But yeah, we've been doing a huge number of those cases. In one day alone, we shut down 10 fairly large affiliate marketers who were using fake news sites as their come on. So, would use the logo of your local news station. I don't know whether it's Channel 6, Channel 7, whatever it is. Breaking news, acai berries, will make you thin or cure cancer or whatever it was. And we shut them down, and we shut down a lot of the larger We shut down a couple of the networks that were engaged in promoting these products. And I mean, in 1 month, we shut down 3 companies that had done close to $1 billion worth of injury. One of them was Canadian, Jesse Wilms. But we had great cooperation from our Canadian counterparts in shutting him down. He may go to jail in Canada.
And that was actually one question that I wanted to pose, if I could, because one of the things that's interesting in any kind of cross-border, I mean, we're now looking at cross-border commerce, cross-border
Right.
advertising, cross-border internet marketing. The notion, at least, that you're working with counterparts in Canada and Europe who may or may not share particular American approaches to either enforcement, deterrence, punishment, or otherwise. I've seen it in, and we talked briefly about other contexts. Securities enforcement context
Right.
is one that I've spent a bit of time looking at.
Right.
In your experience in dealing with, in particular, the North American context, did you find that you were having to sort of bridge that cultural divide with some sort of explanation, or were views relatively the same? I mean, how much international cooperation, how much alignment is there, and where do you say we're going after this enemy?
Right. There needs to be more international cooperation. So we have very good relations with the Canadian authorities, though we can't reclaim money that found its way in Canada to redress injured Americans. Apparently what goes to Canada stays in Canada. And in contrast, when we do redress to people scammed, we will do redress to Canadians. On the other hand, and this is a Sacramento case, so let me talk about that. There's a new scam, really a particularly odious scam, that targets the same people that the Platinum Trust people were. These are people who at some point sought or even took out an online payday loan. So what we have are call centers. These call centers were in India. They were in Mumbai. We knew exactly where they were. We're calling Americans, pretending to be law enforcement officers, and the come on was Officer Smith is coming to your house to arrest you because you failed to pay up your $300 on a payday loan. Unless you agree to pay it up right now, you're going to be arrested, or your child's going to be arrested. It's just terrible things. Now, the guy running this scam is in Sacramento. And he's been indicted by the U.S. Attorney here, and I don't know whether he's pled yet, but we have no shortage of evidence about this guy. But we knew the call centers were in Mumbai. We knew exactly where they were, and we were able to send American film crews to the boiler rooms. Of course, they didn't get in, but they filmed the boiler rooms. Couldn't get the Indian authorities to shut them down. Now, we've had some success in cooperating with the Indian authorities on other matters, but these were very successful scams. The money was all being taken offshore when we shut down this scam. The American, who was really sort of the mule in this, he had almost no money. He has enough money to pay for a very talented defense lawyer, but he has no other assets. And increasingly, this scam, we call this phantom debt collection. We see this coming from other countries with which we do not have very good law enforcement relationships. I mean, we're working now better with the Nigerians. We're working better with the Philippines. But there are boiler rooms, particularly in any country where there are people who speak English. This is why Canada has been a source of real source of problems for us. You will see boiler rooms trying to scam Americans. We are the bank account for the rest of the world, and we are particularly trusting people. There is better and growing cooperation, but it still is very frustrating to know exactly where these scam artists are and not being able to get local law enforcement to shut them down, because we know we're going to see these guys again. Yeah.
What is just the breakdown? It's interesting to me that there seems to be a division of the actual harm to consumers where you're taking
Right.
their value from them, and money laundering, and that one investigated.
Right.
As opposed to a Kellogg's case where people are just kind of falling for advertisements. What is, I mean, they're very different. I don't even want to call one of them a crime as opposed to taking.
Well, and I'm, of course, not calling any of these crimes. That's up for the Justice Department to decide. I think there are a couple of problems with the kind of advertising that we saw. For one, some of these claims weren't very benign. If you're taking a product because you think it's going to prevent or cure mitigated disease, who knows what you're not doing as a result of that. Second, a lot of these products are premium price products, and you are paying a substantial premium for a health benefit that you're not getting. People ought to, I think we can all agree people ought to get what they pay for. And if they're paying for something and they're not getting it, that's not right. The other problem is that you want a level playing field. I mean, one of the things that I found very interesting about my job is that a lot of time was spent with people in industries that wanted more, not necessarily regulation, but wanted a more level playing field. And if you let somebody make claims that they can't support, and the companies that refrain from doing it are injured in the marketplace. And that's not right. And so we don't, we did redress in a lot of these cases. We did redress in, Oric had a vacuum cleaner that killed the flu because they put a UV light on it. Nivea Cream was going to get you into your jeans. We did redress in most of those cases because we wanted to send a signal to advertisers that you can't profit by making claims you can't support. And, in the toning shoe cases, these were otherwise okay shoes. We didn't seek full redress, but we thought we saw substantial redress. We figured we wanted a return between $60 and $80 per pair of shoes to each consumer. And we've been able to do that with our redress programs. And so part of what we're trying to do is not just protect consumers, but protect the competitive level playing field that I think is better for all of us. I mean, cheaters shouldn't win, and this is a form of cheating. That may sound harsh, but it's a form of taking a competitive advantage against a competitor without doing the work. And also, hopefully, some of these claims will prove to be true. I mean, it would be fine if eating a particular vegetable would, in fact, confer a significant health product. But how are you going to distinguish? I don't know if you go to the grocery store, but these kinds of health claims have really proliferated in the last decade because they have a very hard bite in the marketplace. And I think someone needs to patrol the boundaries of that, and that's what we did.
I think that's not right. Is actually something emblematic for the ethics across the professions discussion. And David, really appreciate you bringing your experience, your perspective, and a discussion not only of the ethics of regulatory deterrence, but also trying to create that kind of fair international marketplace to the dialogue this afternoon. I will make sure that I don't start off my day tomorrow with frosted mini wheats and Diet Coke.
Well, just don't think you'll be more attentive.
We'll let others do that. Thank you so much.
Thanks
again.
a lot.
Thank you all very much.